Okay, hi guys, and thank you for joining. Okay, so now we're going to be dealing with application procedure, right? So you have an urgent matter. Your client calls you in panic. Someone is about to sell their property, destroy evidence, remove a child, freeze your client out of a business, or do something that will, cause serious harm. Your client says, please, we need court intervention now. So you rush, you draft papers, you go to court, you stand up confidently, and then the judge does not even want to hear your dramatic story yet. The judge asks, was the application properly brought? Was notice given? Correct parties before court? Is it the notice of motion clear? Are the affidavits properly drafted? Did the respondent get a fair chance to answer? And suddenly, guys, you realize something. In application procedure, the court does not only care about what you want, the court cares about how you got there. So this is why the application procedure matters. So application procedure is not just about throwing papers at court and hoping for justice, right? It's about knowing the exact process used when a matter is brought by application. If action proceedings are the long trial road, application proceedings are the paper road, right? But don't confuse paper road with easy road. Applications can be quick, but they're technical. One wrong step can delay your matter and weaken your case, right? Or even get your application struck from the roll. So today, guys, we're going to deal with application procedure in a way that makes sense, not as boring like rule numbers floating in the air, but as practical courtroom process, right? So by the time that we're done here, I want you to be able to do 6 things. First, you must be able to differentiate between different forms of applications and apply them to a set of facts. You must understand the procedure for hearing an ex parte application, especially with reference to the Audi alteram partem rule, right? Third, you must know the requirements of notice of motion and the correct affidavits used in applications. Number 4, you must know what steps a respondent can take when opposing an application. You must know the time periods within the applications, which the applications can be made and opposed, right? You must also know the requirements of a notice of intention to oppose and the affidavits that follow. That's the entire session. Something that you need to spend like 8 or 10 hours. We're going to do it in 30 minutes, more or less, probably less. So let's build the lesson around these outcomes. But before we continue, if you are studying law and you want civil procedure explained or any other concept explained in a way that actually makes sense, please do subscribe to the channel. And if you want a deeper exam breakdowns, drafting guides and members only case discussions, then consider joining the membership. This is where I go like deeper, step by step and whatever. But now let's get into the business of today. First of all, let's talk about the different forms of application, right? The first thing we need to understand is that not all applications are the same. When students hear application, they often think it is one thing, but in practice, application procedure has different forms, and the form that you choose depend on the facts, right? So the two most important forms are on notice application and ex parte applications, right? The on notice application is an application where a notice is given to the respondent. So, in simple terms, the other side is told someone is asking the court for an order that may affect you. Here are the papers. You have a chance to oppose. This is the normal form of application. Why? Because courts are generally careful about making orders that affect someone's rights without giving that person a chance to be heard, right? So imagine your neighbor is digging near your boundary wall and you believe the digging may damage your property and you want a court order stopping the neighbor from continuing because your neighbor's rights will be affected by that order. the neighbor should generally be given notice. They must receive the application papers and be given a chance to respond. Now, this is an on-notice application. Now, on contrast with that, an ex parte application, right? An ex parte application is brought without giving notice to the respondent. So, in the other words, the application goes to court alone. The other side is not there. Now, guys, that sounds powerful, but it's also very dangerous because our legal system does not like one-sided justice. So the general rule is that both sides must be heard before a court makes a decision that is affecting rights. So that principle is called the Audi alteram partem rule. You already know that. So that simply means that you must hear the other side, right? So whenever you hear ex parte, I want you to think it's an exceptional procedure, right? You don't bring an ex parte application just because you are in a hurry or because you don't like the respondent. You bring it only when the law permits it or where giving notice will defeat the purpose of the application, right? So now let's use a simple example. So imagine someone is about to move money out of a bank account to hide it from the creditors. If you give them notice and say, tomorrow I'm applying for an order to stop you from moving that money, what might they do tonight? They might move the money immediately, and in that kind of a situation, giving notice could defeat the purpose of the application, right? So that may justify an ex parte approach. Another example, if you are applying for certain procedural relief where no other party's rights are immediately affected, the matter may sometimes proceed ex parte, right? So now, the key point is this: on notice is the rule, right? Ex parte is exception. Let's repeat that. On notice is the rule, and then ex parte is the exception. So when you're given a problem question, ask yourself, will the order affect another person's rights or interest? If yes, it should generally be brought on notice. If the facts show real urgency or danger that notice would defeat the purpose, then ex parte may be considered, right? So now, let's talk about ex parte applications and the Audi rule. Now, let's focus properly on the ex parte application. An ex parte application is an application brought by one party without notice to the other party. The applicant appears before the court alone and asks the court for an order. But because the respondent is not present, the court places a heavy responsibility on the applicant. So the applicant must be honest, must be honest, complete and fair in representing the facts, right? So this is called the duty of full and frank disclosure. So in simple language, we can say full and frank disclosure means don't hide the bad facts. So if you are asking the court to make an order without hearing the other side, you must tell the court everything material, including facts that may weaken your own case. You cannot only tell the court the facts that make you look good, right? So imagine you apply urgently and ex parte to stop someone from selling your car. You tell the court this person is unlawfully selling my car, but you don't tell the court that there's a written agreement where you allow them to sell the car if you fail to pay them back, right? That omitted fact is material. So it could change the court's view. If the court later discovers that you hid it, the court may discharge the order and punish you with costs, right? So guys, ex parte procedure is not a shortcut for dishonest applicants, right? It is an emergency or exceptional tool that requires extra honesty. So how does this connect to the Audi alteram partem rule? The Audi rule says that a person whose rights or interests may be affected by a decision should be given an opportunity to be heard. This is a basic principle of fairness. So in civil procedure, it means that applications should generally be brought on notice to the respondent. So when we bring an ex parte application, we are temporarily moving away from the Audi rule. That is why the court is super strict. So the court wants to know, why should I hear you without the other side? Why can the respondent not be notified? What harm will happen if notice is given? Is the matter genuinely urgent? Are you being fully honest? Right? So in a test or an exam where you discuss ex parte applications, don't just say it is an application without notice. That is not enough. You must connect it to the fairness. You must say that ex parte applications are exceptional because they limit the respondent's opportunity to be heard, and therefore the applicant must make full and a frank disclosure, right? You can simply say something like this: an ex parte application is brought without notice to the respondent and is therefore an exception to the ad alteram partem rule. Because the respondent is absent, the applicant has a duty to disclose all the material facts fully and frankly, including facts that may be unfavorable to the applicant. That is the kind of sentence that gets you marks, all right? Now let's move on to the notice of motion and supporting affidavits. So now this is like the heart of the application procedure, the notice of motion. If application proceedings are a vehicle, then the notice of motion is the steering wheel, right? It tells everyone where the application is going. A notice of motion is the document that tells the respondent and the court what order the applicant wants. In all civil courts, right? An application is generally brought by notice of motion supported by affidavits. In the High Court, ordinary applications are governed by Rule 6 of the Rule 6 of the Uniform Rules of Court. And in the magistrate courts, applications are dealt with under Rule 55. So Rule 6 provides that applications are brought on notice of motion supported by affidavit, and Rule 55 similarly provides for substantive applications on notice of motion supported by affidavit. Now let's make this practical. The notice of motion must state the order sought, right? This means that it must clearly set out what the applicant wants the court to do. For example, it may say the applicant seeks an order interdicting the respondent from demolishing the boundary wall, or the applicant seeks an order compelling the respondent to return the applicant's motor vehicle, right? Or the applicant seeks an order declaring the respondent's conduct unlawful. The order must be clear. It must not be vague. It must not be confusing. The court must be able to take the wording of the order and make it an order of court. If the wording is messy, the court may struggle to grant the relief. So guys, when drafting a notice of motion, don't write like someone sending a WhatsApp complaint. Write like someone asking a court for a precise legal order. Instead of saying, please stop the respondent from disturbing me, you can say, the respondent is interdicted and restrained from entering the applicant's property situated at number 1 Hoffman Street without the applicant's written consent, right? So that is clearer, that is enforceable. The notice of motion must also identify the parties. The applicant must be named, the respondent must be clearly named. In a High Court application on notice, every person who has a legal interest in the matter must be cited as a respondent. Why? Because if the court order may affect someone's rights, that person must be before the court, right? So let's give an example. If you are applying for an order affecting property jointly owned by 3 people, you cannot cite only one person and ignore the others. The other owners may have a direct legal interest as well. So they must be joined so that the court does not make an order behind their backs. The notice of motion must also be addressed to the respondent and to the registrar or the clerk of the court. This is because the respondent must receive the papers and the court must know what matter is being placed before it, right? The notice of motion also tells the respondent what steps to take if they want to oppose. So this is very important because it gives the respondent procedural instructions. It tells them when and how to deliver a notice of intention to oppose, right? And then when to deliver the answering affidavit. So the notice of motion is supported by affidavits. The first affidavit is the founding affidavit. The founding affidavit is the applicant's main evidence. It sets out the facts which the applicant relies on. So it must contain enough factual detail to justify the order sought in that notice of motion. So in simple terms, the notice of motion says, this is what I want. The founding affidavit says, this is why I deserve it, right? So, for example, if the notice of motion asks for an interdict, the founding affidavit must explain the facts showing why the interdict should be granted. It must attach supporting documents when necessary, such as contracts, emails, photographs, letters, reports, and so on. So now, guys, remember, in application proceedings, your affidavits are your evidence. You don't need to get to stand up later and casually add news stories from the bar. Your case must be in the papers. That is why the founding affidavit must be properly drafted. It must contain the material facts, not just conclusions. Don't write the respondent is acting unlawfully. That is a conclusion. Rather explain, on 3 March, the respondent entered the applicant's property without consent. On 4 March, the respondent sent a message stating that he would return the next day. A copy of the message is attached as Annexure A, right? So that is factual, and that gives the court something to work with, right? Good. I hope you're still following. So now, how the respondent opposes an application. So now let's move to the respondent, right? The respondent receives the application papers and must decide what to do. So the respondent has options. The first option is to do nothing. If the respondent does not oppose, the application may proceed as an unopposed application, right? The court may then hear the applicant and grant the order if the paper is justified, right? That's option 1. Option 2 is to oppose. If the respondent wants to oppose, they must usually deliver a notice of intention to oppose, right? A notice of intention to oppose is a short document where the respondent says, I intend to oppose this application. It also usually provides an address where the respondent will accept service of further documents. The notice is important because it tells the applicant and the court that the matter is no longer unopposed. It is now opposed. After delivering the notice of intention to oppose, the respondent must deliver an answering affidavit, right? The answering affidavit is the respondent's main evidence. This is where the respondent deals with the applicant's allegations. The respondent must admit, deny, or explain the facts. We dealt with this in the other lesson, right? So if the respondent denies something, the respondent must do so properly. This connects to what we discussed in the previous lessons on bare denials, right? A respondent cannot simply say, I deny everything. There may not create a real dispute of that may not create a real dispute of facts, apparent. So the respondent must seriously engage with the applicant's facts, right? So, for example, the applicant says, the respondent signed the agreement on the 10th of January. So a copy of the signed agreement is attached. A weak answering affidavit will say, I deny signing the agreement. A stronger answering affidavit says, I deny signing the agreement. I was not in Cape Town on the 10th of January. I was in Durban attending a work conference. I attached my flight confirmation and my hotel invoice. I further state that the signature appearing on the document is not mine. So now the respondent has given the court a real answer. After the answering affidavit, the applicant may deliver a replying affidavit. The replying affidavit is not meant to create a brand new case. It is meant to respond to new issues raised in the answering affidavit. The applicant must generally make their case in the founding affidavit. They cannot save important facts for reply just because they forgot to include them at the beginning. Think of the affidavits like a conversation. The founding affidavit says, here is my case. The answering affidavit says, here is my answer. The replying affidavit says, Here is my response to your answer. So that is the basic structure, right? And then let's move to the most important, the time periods for making and opposing applications, right? Now, this is where we usually get nervous because we start talking about days, but don't panic. Think of the time periods as the applicant, like applicant's timetable. Let's call it an applicant's timetable. So in ordinary High Court applications, the notice of motion must usually give the respondent time to indicate whether they intend to oppose. A common ordinary rule 6 pattern is that the respondent has 5 court days to give notice of intention to oppose, then 15 days to deliver an answering affidavit, and the applicant then has 10 days to deliver a replying affidavit. So in simple terms, the notice of intention to oppose, usually 5 court days. Answering affidavit, usually 15 days after the notice of intention to oppose, right? Replying affidavit, usually 10 days after the answering affidavit. In the magistrate courts, Rule 55 application forms require the respondent to give notice of intention to oppose by the date stated in the notice within 10 days after giving notice of the intention to oppose, right, to file the answering affidavit. So now, guys, you must be careful. Time periods can depend on the type of application, the court, the rules, practice directives, and whether the matter is urgent. So in practice, you always check the applicable rule and practice directive. But for study purposes, you must understand the logic. The logic is this. First, the applicant serves the application. Second, the respondent gets time to decide whether to oppose or not to oppose, right? Third, if the respondent decides to oppose, the respondent files an answering affidavit. Fourth, the applicant may reply. Fifth, the matter is set down for hearing. So, in urgent applications, the court may allow shorter time periods. This is because urgency means the applicant cannot wait for the normal timetable. But urgency must be real. You cannot create urgency by waiting too long and then suddenly rush to court, right? For example, if someone sends you a letter today saying they will demolish your wall tomorrow, urgency may be real, but if you have known about the problem for 3 months and only come to court the day before the demolition, the court may ask you why you waited so long. So guys, urgent applications are not for people who slept on their rights. Urgency must be explained in the founding affidavit, right? Last topic, notice of intention to oppose and affidavits. Now, let us deal more specifically with the notice of intention to oppose. The notice of intention to oppose is not the respondent's full defense. It is just a formal notice that the respondent intends to fight the application, right? It must usually identify the respondent, state the respondent intends to oppose, and provide an address where the documents can be delivered. So the real defense comes later in the answering affidavit. So don't confuse the two. The notice of intention to oppose says, I am opposing. The answering affidavit says, yes, this is why I'm opposing, right? So the respondent must be careful, because if they deliver a notice of intention to oppose but fail to deliver an answering affidavit, the application may still proceed. The court may treat the matter as opposed in form, but there may be no evidence from the respondent to contradict the applicant's founding affidavit. This is dangerous. So it's like entering the boxing ring and then refusing to throw punches. If you oppose, you must put up your evidence, right? So now the applicant's affidavit and the respondent's affidavit must be sworn statements. So that means that the deponent confirms the truth of the contents under oath or affirmation. So a deponent, you know what that is, right? A deponent is the person who signs and swears to the affidavit. If the applicant is a person, the applicant may depose to the founding affidavit personally. If the applicant is a company, someone with knowledge and authority, such as a director or manager, may depose to the affidavit, right? So the affidavit should usually include the deponent's identity and capacity. So the facts with the deponent's the facts within the deponent's knowledge, the basis for the relief sought, references to supporting affidavits, a clear link between the facts and the order requested. For example, if a company applies for payment, the deponent should explain their role in the company and how they know the facts. They should not simply say, I'm authorized. They should show why they can speak to the matter. So in applications, the court relies heavily on affidavits. So if the affidavit is vague or weak or unsupported, the application becomes weak. So let's bring this whole thing together now. First, decide whether application proceedings are appropriate. Remember, applications are suitable where the matter can be decided on papers and there is no serious factual dispute requiring oral evidence. Second, decide what type of application it is. Is it on notice, ex parte, urgent, interlocutory, opposed or unopposed? Third, draft a notice of motion. This document must clearly state the order sought and tell the respondent what to do if they intend to oppose. 4, you draft the founding affidavit. If the applicant's main evidence must set out the facts supporting relief. 5, you attach the relevant annexures. Annexures are supporting documents attached to the affidavit. These may include contracts, emails, letters, photos, invoices, bank statements, whatever, right? 6, you issue the application at court and serve it on the respondent unless it is ex parte, right? 7, you wait for the respondent's notice of intention to oppose. If the respondent opposes, receive the answering affidavit, right? 9, deliver the replying affidavit if necessary. And then 10, you set the matter down for hearing. 11, argue the matter in court on papers, right? 12, the court grants or refuses the order. That is application procedure in simple and practical sequence, right? So now let's try to apply this. Thandi owns a house. Her neighbor is Sizwe. Sizwe starts digging near the boundary wall. Thandi believes the digging will damage the wall. She has photographs, a builder's report, and WhatsApp messages showing that Sizwe intends to continue digging. Should Thandi bring an application, right? Yes, most likely. She wants an interdict to stop Sizwe from continuing. The matter may be urgent, right, or semi-urgent, and the evidence can be placed before court in documents and affidavit. Should it be ex parte? Usually, no. Sizwe's rights will be affected. He must generally be given notice or a chance to respond. So this should generally be an on-notice application. The notice of motion will state the order sought, that Sizwe will be interdicted from digging within a certain distance of the boundary wall. The founding affidavit will explain the facts, ownership of the property, what Sizwe is doing, and why it creates risk, why or what evidence supports the risk, and why the court should intervene, right? And then let's now give you an example on ex parte application. So now imagine a different scenario. A company discovers that its former employee has confidential documents and is about to destroy or hide them. If the company gives notice, the employee may delete everything before the court can act, right? So in that case, the company may consider an urgent ex parte application, but the company must explain why notice cannot be given. It must disclose all the material facts, including anything that may weaken its case. It must satisfy the court that the situation justifies proceedings without hearing the other side first. That is how the alteram partem remains important, right? So even when the other side is not initially heard, the court remains concerned with fairness. Okay, now we're going to close it like this. Let's move into exam mode or test mode. So if a question asks you to discuss application procedure, you don't write randomly. Structure your answer around the process, right? You can say application proceedings are motion proceedings in which evidence is placed before court by way of affidavits. An application is generally brought by notice of motion supported by founding affidavit. The notice of motion states the relief sought, while the founding affidavit sets out facts relied upon. Where the application is brought on notice, it must be served on the respondent, who may deliver a notice of intention to oppose and thereafter an answering affidavit. The applicant may then deliver a replying affidavit. The matter is then set down for hearing and argued on papers. Then, if the question involves ex parte applications, then you can always say that ex parte application is brought without notice to the respondent because of A, B, and C, right? Like the way I explained before. So it's not that difficult. It just sounds a little bit technical, but it's not that difficult. So a final recap before I close, I'll just say, let's have just the memory version, right? An application is a paper-based procedure. It is brought by notice of motion supported by a founding affidavit, right? The applicant seeks for an order. The respondent may oppose by delivering a notice of intention to oppose. The respondent may then file an answering affidavit. The applicant may reply with a replying affidavit. If the application is on notice, the respondent is given a chance to be heard. If the application is ex parte, the respondent is not initially notified, so the applicant must make full and frank disclosure. The audio alteram partem rule means hear the other side, right? And the most important practical point is, in application proceedings, your papers are your case. If the facts are not in the affidavits, they are not properly before the court. So guys, when you think of application procedure, think of a paper trail. The court is not listening to witnesses. The court is reading your documents. That means your notice of motion must be clear. Your affidavits must be complete. Your annexures must support your story, and your procedure must be correct. So if this lesson helped you, please like the video and share it with your friends. Okay, I will see you on the next lesson where I'll be talking about action. So we've done action or application. Now this is application, and then we're gonna do action in detail. Thank you so much, and no sleeping for the wicked.